Hello, my name is Monika Hengesbach. I'm an enrolled agent, NTPI Fellow, and welcome to the Wealthy Wallet. Today, I'm super excited to have us on. My guest is Aron Phillips. He is the owner of the law office of Aron Phillips. Aron and I go back quite some time now, and not only is he my personal business attorney, but he also happens to be a great friend of mine. And so I'm really excited to have you on. Last week, we had someone on from the bank, and they talked about mortgage interest and help for some of my real estate investors. And so now I think it'd be really great for a lot of the new entrepreneurs to have a little bit better understanding of the legal aspect. So Aron, why did you decide to get into law?
So that's a somewhat complicated question. I would say the simple reason is when I was younger, I read rule books for fun. Literally, there were board games that would have rule books that were over 100 pages, and my friends would call me with questions, and they had the rule book sitting in front of them because they knew that I'd read everything cover to cover, sometimes even for rule books that I hadn't read, because they would say, well, you know this stuff, Aron. So that's probably the main just skills-wise translation of why I went into law, because now I do contract law, so every contract is just a set of rules for that relationship. For me, also, though, faith is a big part of my life. So in my last year of college, I was an English lit major with a philosophy minor, so there's not a lot of ways to feed yourself with that. And people were asking me, what are you going to do post-college? And I would answer with, well, I might go do mission work, I might go to grad school, I might teach, I might go to seminary, or maybe law school. And I'd always list that last. And then I had about 5 or 6 conversations with some mentors or older, wiser people in my last semester. And they would always end the conversation by asking, well, what would you pick out of that list? All other things being equal. And I would say, law, I think. And so then they would leave, and I would hear God's voice in the back of my head, well, if you want to do law, why don't you just go do law? And so after the 5th or 6th time, I was like, okay, God, I'm going to take the LSAT. And if I bomb it, we're not going to law school. So I signed up for the LSAT. I studied for 3 weeks, and I did not bomb it. I ended up going to Baylor Law, had a scholarship. It all worked out. So,
well, that's wonderful.
Yeah.
Well, thank you. Again, thank you for being on here. I'm really excited. So what are some of the pitfalls, some of the common legal pitfalls that new entrepreneurs may encounter when starting a business?
So the most dangerous thing, and I'll also start by saying nothing that I say on here is legal advice for anybody listening, just as a disclaimer.
Typical attorney.
I don't know the facts of your specific situation. So we're just talking in broad principles here, or giving specific anecdotes related to facts that I've seen or facts that she presents. But nothing on here should be taken as legal advice for your situation. Make sure you consult with an attorney for your specific situation so that you can get the right legal advice for you. That having been said,
thank you.
No problem. So I would say the pitfall is you don't know what you don't know. And then a lot of entrepreneurs, they have a lot of times a hard charging can-do attitude, which is useful in being willing to take risks, but will also bite them in the butt, because they will end up taking risks on the legal front and end up, having no contract or a very weak contract in situations. So it's a situation where I would say as soon as you can possibly afford certain professionals, use them, because if you get insurance, you have to get an insurance agent. I mean, you don't have to, but most entrepreneurs still go to an agent, even though technically they might be able to find a slightly better rate by themselves, but that's a might and slightly better. So the margin's not there. So they think I should go to an agent. Well, in the same way, you're incurring a legal debt when you choose to do a bunch of legal work yourself. You're just not realizing it until something ends up biting you in the butt in terms of some sort of liability or a contractual situation where someone doesn't pay or sues you. And so, understanding that usually, even though the legal fee may feel not great, it is usually, if it's good legal work, it's going to be a fraction of what the ultimate cost will be on the backside. A quick example from a case that I have going right now. It's in litigation for over $2 million. They've spent over or $500,000 in attorney's fees. I brought in a larger firm to help me because I don't do litigation myself. I've been doing this one and helping with that, but the larger firm's done most of the work. But they spent $400,000 or $500,000 in attorney's fees.
Wow.
Or more, and we still haven't gone to trial, so they're going to be spending another 100.
Oh wow.
And they could have avoided this with probably $10,000 or $20,000 or less spent with me on the front end related to a merger and acquisition situation. But they did it themselves, thought it was a situation where they were willing to take the risk. There were risks involved, and the blowback has been, many times over what the fees would have been on this situation. So I think being concerned with the monetary portion is a mistake also when it comes to contracts. So sometimes people will get a lease, for example. That's an easy one. The front page of the lease says the rent amount, the term, the build out allowance. And so people will go, oh, they gave me everything I wanted. But the lease might be 15 or as much as 45 pages long. I've seen some. So you got everything you wanted, quote unquote, but there's another 14 to 44 pages that have nothing to do with what you wanted and everything to do with what the landlord wants.
Yeah.
So if you're only concerned with page 1 and you don't have an attorney review the other 90-something% of the lease, you can end up with a situation where you have a horribly one-sided contract. So that's another pitfall. Another one is also just not calling the attorney soon enough. So, once you get up and going, I had one client that had a lease situation and they spent a lot of money paying a landlord when they shouldn't have even been paying the landlord. If they had called me or another attorney and said, here's the lease, here's what's happened, the landlord hadn't provided AC from day one in Texas. So I would have said, don't pay rent until that AC is running. But they paid rent for 18 months, over $180,000 in rent. And then they called me and said, I can't afford a retainer. Well, you should have called me on day one when you could afford the retainer before you ran out of money, and then you wouldn't have paid the landlord a dime until he fixed the thing. So, call the attorney sooner generally heads things off at the pass as opposed to letting things build and build and build. So those are a few different pitfalls, but I mean, there's, it just depends on any situation. There's pitfalls I can't even think of probably just because there's so many different ways to step in it.
So in the one that you just mentioned about the air, just out of curiosity, the one that you mentioned about the air conditioning unit and the client paying 18 months, was there any recourse for them to get back any of that rent because they were living? I mean, how could you be in an office in Texas with 100 and bazillion degrees and no air conditioning? It's inhumane.
They couldn't. It was insane. And it was a spa as well. So,
good Lord.
They couldn't operate, literally.
No.
And was there recourse? Yes. But it's a situation where unless you can get an attorney to take it on contingency, they're not going to. And because they couldn't afford the retainer to go to litigation and try to press the landlord. And those kinds of cases are marginal on contingency because while, the public and some of the media like to say there's a lot of frivolous lawsuits out there, most lawsuits, I would say, the vast majority of them are not frivolous because if somebody's willing to pay an attorney to go do it,
right,
then they're staking their own money on paying somebody to go do it. And then if attorney is taking it on contingency, they're not taking bad cases on contingency. So either way you slice it, people are going to court because they think they have a good case or the attorney does.
Sure.
But in those cases, like in that case, it would be marginal to take on contingency because you don't know if the landlord has the money anymore, if it went other places like to the mortgage or other things like that. And the landlord might be difficult to collect against. And so there's all kinds of collections issues, whereas cases that are traditionally contingency work are personal injury cases where usually insurance companies are involved and the traps and the processes are known in terms of how the payout will be reached and how collection will work.
Sure. Okay. So really the way that new entrepreneurs can avoid some of these pitfalls is to actually treat attorney fees or such almost as if it's an insurance. It's a necessity to be successful in business where they consult with an attorney prior to getting to signing a lease or setting up a contract or getting into business with somebody else. be one of the ways to try to avoid those types of pitfalls.
Oh, yeah.
I know in my practice, every prospective client comes in and they go, well, my next door neighbor said I should be an LLC, or my parents said I should be an LLC. So I decided to be an LLC. And sometimes it's great to be a limited liability company. Sometimes tax-wise, it's not a great thing. Can you talk about the different types of structures and what structures might suit different businesses better?
Sure. So I'll make a differentiation also real quick between legal structure versus tax structure, because I'll have clients where I'll ask them, what are you? And they'll say, well, I'm an S corporation. And I'm like, okay, but in terms of legal structure, what are you? And they'll say, well, I'm an S corporation. And I'll say, okay, are you an LLC or are you a corporation? Do you have bylaws or do you have a company agreement or operating agreement? Because the two things are different. And so the legal structure, that's something that's state by state. And I know you know this, so I'm just doing this for the benefit of our audience, but that's state by state. So there's the Texas Secretary of State, there's secretaries of business in some of them, or secretaries of commerce, but whichever one you call it, there's a system where you file a certificate of formation or articles of incorporation. In I think over 40, maybe even 49 other states, it's articles of incorporation, but Texas is special and we call it a certificate of formation for no apparent reason. Also,
for Texas.
Yeah. Also, for an LLC, the operating document, the governing document in 40, maybe 49 other states is an operating agreement. In Texas, it's referred to as a company agreement because we're special. So anyway, in all of the states, you register and you form the entity by registering with that state. So with the Texas, it'll be the Texas Secretary of State. You file the certificate of formation. And then you can form a corporation, you can form an LLC. Technically, partnerships are not formed by filing that document. Partnerships are formed by an agreement. So you should have a partnership agreement, and that's technically what forms the partnership, whether it's a general partnership or a limited partnership. And then when you register with the Secretary of State, you're merely basically notifying the Secretary of State that this partnership exists. You don't even have to register general partnerships. So in terms of legal structure, 90-something% of the entities that I see formed these days are LLCs because on the tax side, LLCs can be taxed in pretty much all of the major ways. And so you have, there we go. So you have S corporation, disregarded entity or sole proprietor, partnership if there's multiple people, and then C corporation. Those are the four major ones. There may be other ones, but that's your sandbox. So I won't expound further on those. But in terms of all of those can be an LLC for the legal structure. So an LLC can be taxed whichever way is most useful. So that's why I see over 90-something% of small businesses form LLCs, because then they get the liability protection and the tax structure can be whichever one is most advantageous. Whereas, for example, a corporation cannot be a disregarded entity or a partnership. A corporation has to be some kind of corporation, so either a C corporation or an S corporation. And so the LLC has that kind of Swiss Army knife approach to the tax structure that's really useful. If you're planning to go public, though, or fundraise, and I mean capital raise like millions, not like, hey, I got my dad to give me $50,000 or, something to start this company, but I mean going and seeking venture capitalists, then a corporation may be more useful because there's just a lot more familiarity with that process in terms of the structure for corporations. And a lot of times you're going to end up being a C corporation just because they'll want different classes for different investors, different rounds of investors. You can't have different classes for an S corporation. So that leaves C corporation, and they don't want a partnership of any kind. Generally, it used to be limited partnerships were very popular as a quick aside, but LLCs have kind of become more popular because LLCs can accomplish most of what limited partnerships were doing. Although, to foreshadow a later point, the Corporate Transparency Act may bring limited partnerships back into popularity. So we'll see. Did I answer the question? I feel like I rambled a bit.
I know. I think you did answer the question because you did talk about the different structures. And Actually, my next episode is going to be on the tax savings based upon those structures. So this was kind
Perfect.
of really critical. I want to throw this out there, though. Why? Because when people come to me and I say, I recommend you be an LLC and have it taxed as an S corp, they'll immediately go, "Oh, can I do LegalZoom?" And I'm sure LegalZoom to you is like TurboTax to me.
Mm-hmm.
But why should someone, instead of using LegalZoom, because all the advertisement says, well, it's backed by all these attorneys, why should someone use you for the incorporation process versus doing it by themselves through LegalZoom?
So I think it comes down to a couple of different things related to how they perceive value. So if they're the kind of person that is going to use TurboTax and is okay with the potential audit risk and the potential loss of tax savings, right? Because they might not realize what they need to enter and how to get the tax savings. Then they're also the kind of person that will use LegalZoom because they're okay with the risks associated with essentially drafting your own documents. And when I say drafting your own documents, I really do mean that, because LegalZoom will pump out a form document. Well, even though I start from a form, it's not like I start with a blank Word doc every time I type up something for people, right? So I start from a form, but I craft that for that client's situation. If there's tweaks here and there that need to be made, I make them. And you as an individual that don't practice law don't know what tweaks need to be made in that agreement, whether it's 5 pages or 50 pages. The main points, referring back to my earlier point, what you might want on page 1. Here's the owners, here's how much we've contributed. But in terms of how the legal governing documents should be structured, you don't know what you don't know, and that can hurt you. Now, the risk, to be for the purpose of intellectual honesty, I'll say the risk is lower if you're a single member entity and you're not having any other owners and you're just starting out. So in that situation, if I was going to say, if anyone was going to use LegalZoom, they're the people that are where it's probably least likely to bite them in the butt. But that said, if you're going to add anybody in the future or get into any situations where those kind of documents are going to come into play, it probably would have been better for a marginally higher cost to get that done by an attorney rather than risk the tens, hundreds of thousands, $1 million liability later. I would also add, getting that relationship started is also useful. So those points that I made earlier, if somebody calls me out of the blue who I've never met before, then they're going to need to get a consultation. I'm going to have to review some of that stuff anyway. So some of those costs are going to be baked into me getting up to speed. Whereas if somebody calls me out of the blue and I've formed an entity for them, I might call them back and do a 5-minute call and not bill them, because they have a quick question.
Sure.
And because we've already got that relationship. So having that relationship can also pay off, because if you do have that quick question here or there, or if it is a bigger thing, then we can schedule a meeting and it will be billable time. But then there's still less time taken to get me up to speed, because we can jump right into that meeting and get right into the meat, as opposed to me having to hear the backstory or look at the other documents.
Sure.
So another point, just for the legal issues within LegalZoom, they may be backed by different attorneys and law firms, but they explicitly disclaim that there's any attorney-client privilege when they give you the documents. So it really is TurboTax. There's nobody you can go sue. You're basically taking your own legal advice into your own hands there, because they're disclaiming any attorney-client relationship, any legal advice being given.
Sure.
Because you're entering the information yourself about what you need. So sometimes, I've not gone through the process with LegalZoom because I don't want to pay to get some forms. But theoretically, you could get the wrong forms. Just like on TurboTax, if you don't know what you don't know and you enter the wrong thing in the wrong place, you'll get the wrong answer at the end.
Sure.
So if you give the wrong information to LegalZoom because you think you need an agreement and it's called this, but LegalZoom calls it something else, and there's not a person asking you specific questions to figure out what's the purpose of this document, you may end up with a document that doesn't even do what you wanted it to do.
Yeah. And then you just wasted the money of paying that you tried to save money on. You just wasted it anyways. So in your experience, what are some of the legal considerations new business owners should keep in mind when they're drafting contracts or agreements with partners or clients or vendors? What should they keep in mind when they're doing that?
So not to sound like a broken record, but they should not draft their own contracts for a start. But the part of the reason for that is sometimes people may think we've got all of the details figured out, but really the legal details are more than what's on the first few pages or what can be summarized in a term sheet or a letter of intent, because there are just a lot of different issues that a contract is meant to cover. So, people sometimes are obsessed, in my opinion, with having a short agreement. They'll say, oh, can we keep it as short as possible? And what you're really doing is you're short-circuiting the amount of issues that can be covered that might cause liability later. Every single paragraph that you take out, let's pretend that's $1 million liability that would have been dealt with by that paragraph. And you just cut that out because you wanted it to be a little shorter. Good job. There's a little more exposure for you. I had that happen with a client once in a merger and acquisition deal where we were going through the agreement I had drafted, and they said, oh, that won't happen. We can cut that. Oh, that won't happen. We can cut that. Oh, we're not going to go to court, so we can cut that. And we got about halfway through, and I had to stop and say, you guys understand nobody plans to go to court. Like, nobody wakes up and says, I want to go to court in a few years, so I'm planning to put this in this document. These things are in this document to protect you in case that happens for any unforeseen reason. So it is my strong recommendation that we stick basically everything that you just had me cut out back in. And if you like it out, that's fine. But understand, nobody plans to go to court. And if you end up in court for any of the reasons that were in those provisions, then you've just caused yourself a lot more in attorney's fees later. And so, also sometimes business owners or whoever it is that is on the different sides of the agreement, they'll have ways that they think something should be structured, but an attorney who's seen that kind of contract a lot of times might have a more elegant way of structuring something that serves both parties' interests. And sometimes, to the point that was just made, the attorney's documents will generally cover more issues. And so in terms of when drafting agreements with partners, clients, and vendors, so I'll take those in order. When you're dealing with partners, you want to think about, kind of similar to an estate plan, all the things that you don't want to think about right now. What happens if they divorce? What happens if we hate each other's guts in 3 years? What happens if, and get that dealt with. So that's what I call a buy-sell agreement. So that way there's clear outs that can occur. But even a buy-sell agreement might not cover everything under the sun. There might be something that comes out of way left field that's just, nobody thought of, even if the agreement covers several dozen different things. And so, but covering as many things as possible limits the chances of that. And then also, if you have the framework to fall back on, if something comes out of left field, then you can go, okay, well, we already have this framework, so let's try to fit that within this framework as opposed to just dealing with this in some nebulous situation. Also, in agreements with partners, you want to think about who's getting paid how much in the future. So distributions, if I put in $500,000 and you put in $0, but you're the brains, when we start making a profit, are we prioritizing me getting my money back? And in the meantime, are you getting a salary? So we need to cover those issues. Also, what happens if we need money in the future? So subsequent contributions need to be talked about.
That's a big one. That's a big one that I come through, is that specific, how are the partners getting paid? Because it is usually one has the money.
Yeah.
And the other one has the brain or the brawn or however you want to word it.
Yeah.
And they're taking distributions out, but so is the other partner's taking distributions out. And here one partner's capital count is negative and the other capital count of the other partner is flourishing. He goes, well, wait a minute, that was my salary. Well, no, that's not how you structured it. You just structured that you're going to take distributions out. So I think that's really critical. So sorry about that interruption.
No, yeah.
I felt I needed to add that in there.
Yeah, yeah. When dealing with clients, there's also, and I'll say for all three of these, actually, as a quick aside, in negotiating generally, it's important to look at things as objectively as possible. A lot of times people will say, well, I just want X or Y, because they feel like they should get whatever. And it can create a situation where somebody has unreasonable expectations. So it's important to try to be able to articulate why you want what you want in a given situation, because that will make the negotiation process more merits-based as opposed to just well, I want it this way, not to throw banks under the bus, although I actually don't mind throwing them under the bus too much. But banks, since you had a guest from a bank on
I
last
did.
time,
I'm sorry, Sharon.
but banks, when I've negotiated with banks for loan agreements, I've negotiated with multiple lenders on loan documents, and generally banks are, well, this is how we want it, and if you don't want it, you can go try to find the money somewhere else. So they will change parts of the loan agreements, but there are many, many, many parts of the loan agreements that they will just not change, even if there's good reason to change it. At least in my opinion, representing the borrower.
Right.
So they won't articulate a reason for it. For example, one that's industry standard, so I'm not throwing any particular bank under the bus, just the whole industry, is every single loan document that's commercial.
You said you weren't going to be controversial.
Sorry, just a little.
Yeah.
Every single loan document that's commercial, I don't know if it's for mortgages too, uses a 360-day year instead of a 365-day year for interest.
Oh, really?
calculations. Yeah. And so they're getting 5 or 6 extra days of interest because it's a 360-day year times the actual number of days, if you go read the paragraph. So they're getting extra interest for no apparent reason. If you push back on it and say, well, there's actually only 365 days. There's actually 365 days in the year, so we need to structure that provision to be tied to reality, please. The bank will say, well, sorry, that's industry standard. That's how all of our documents have it, and that's how everybody in the industry has it. So too bad, so sad. But they have no articulable reason for that other than we want it, and it gives them just a little bit extra money.
There you go.
Yeah. So back to the legal considerations. When you're dealing with clients and vendors, for clients, with all three, I think just broadly speaking, you want to think about situations where they may take something from you that they're not supposed to, or where they may create exposure for you from a liability standpoint. So with clients, if they give you the wrong information, for example, in both of our fields, we are very dependent upon what the client tells us.
Yes.
So if the client lies to us all the way through, and then there's a problem later, we're only as good as the information that we're given.
So true.
And so having something in our engagement letters that says, you are attesting to the accuracy of the information you give us, we are relying upon it, and, if it's inaccurate, we cannot be held responsible for any advice given based on inaccurate information, something like that. Like that's a situation that we would need to consider for a roofer, since we talked about roofers a little bit earlier.
We shall leave you all nameless.
They might want to consider exactly how the warranty looks. For example, what are they going to cover? What are they going to not cover? They might want to have things in there. If you're talking about vendors, they might want to have things with their vendors related to which warranties will pass through, because the roofer probably doesn't make their own roofing material. They probably buy it from somebody. So is that warranty from the vendor going to pass through to them, to the client, or not? So making sure there's clear boundary lines and who's responsible for what from a legal standpoint is important. And I've reviewed a lot of different documents from master service agreements, subcontracting agreements, and things like that. And that's usually the section that gets the most attention from a legal perspective, just because you want to make sure that the lines are really clear about who's responsible for what.
Because in the case of a lawsuit or litigation, if it's a product defect, then you can't necessarily go through the roofer. You have to go through the manufacturer of the shingles, for example, right?
Yeah.
Or do you name everybody in there and the biggest fish? Because see, that seems to be the misconception. It's like, we're going to bring everybody into this pond, and the big fish is going to get it because they have the deeper pockets. But that's not necessarily the case, is it?
That is a strategy for many plaintiffs' lawyers. But the just pragmatically, I mean, that's what a lot of them do, just because if all of them might be liable, then include them all, and then we'll sort it out as we go through discovery. But yes, to your point, a lot of times, not always, and I don't focus on products liability, so please double check this if you ever have a situation like this with an attorney that specifically does products liability litigation. But a lot of times, a seller who has not messed with a product in any way, shape, or form is not able to be held liable because they literally got the package and gave it to the client. Now, in the case of a roofer, they did touch the package because they put the roofing material on, right? So I'm not sure how it would play in there. A different example that would be a little more clean cut in my head would be you buy a lawnmower from Home Depot. okay, something goes wrong with the lawnmower and it causes, blindness in some child or something by spewing metal. You're probably not going to be able to sue Home Depot. I mean, you could try, but they just got the lawnmower in a box and sold it to you. So it's DeWalt or Ryobi or whatever the manufacturer was that made the bad product that's probably going to be ultimately liable.
Okay. That makes sense. Well, that leads into my next question, which is, how can businesses effectively manage risks associated with commercial transactions? I mean, you spoke heavily about mergers and acquisitions, joint ventures, or franchising agreements.
Mm-hmm. So I think, first off, for all three of those are definitely bigger transactions. So not to sound like a broken record, but get an attorney because you don't want to end up in a multi-million-dollar lawsuit over that situation when you could have paid, a fraction of that, So for franchising, I'll actually cover each of them a little bit separately. Franchising, you want to make sure you get an attorney because the franchisor has an attorney. I guarantee you the franchisor has an attorney because to become a franchisor, you have to have an attorney. It's almost like going public. There's a lot of different documents that you have to file with governing agencies. And so they've got an attorney that drafted these documents, which, franchise documents are usually a stack of documents that's anywhere between 50 and 200 pages, or more sometimes. I've reviewed several of them for people that were getting into franchises or, in a couple of instances, people that were already in franchises. And when you're already in it, you've already signed on the dotted line. I'm really just seeing what options you have at that point. But on the front end, if you get an attorney, they can tell you, okay, here's what you're signing up for. So at least you go and do it with your eyes wide open. Now, usually franchisors are not going to change the agreement, similar to banks, how I just talked about, because they're saying, this is our franchise, take it or leave it. They might change a few little things here and there, but it's important to go in with your eyes wide open and have somebody on your side that's asking questions, even with due diligence issues. I had a client, or a non-client really, who had a franchise. It was a trampoline park, and they had opened up. They'd been open less than a year. He called me in December, and he said, I need to sell my trampoline park. So I thought, oh, okay, it's an M&A deal. And he said, I need at least 1.2, 1.3 million. We would settle for 1.1 maybe. And I'm not a business broker, so I didn't, try to appraise it or anything, but I know enough to be dangerous. So I asked him a couple of questions. I said, okay, well, how much did you make in the last year? He said, well, we've only been open since April. And I said, okay, well, have you been profitable? He said, well, we were until August. And so I was like, so you haven't been profitable since August. So in my head, red flags are going up. Like, who's going to pay over $1 million for something that's not even profitable? So I ended up getting coffee with him, and I brought a business appraiser with me so that guy could speak a little more bluntly about the appraisal process and what the thing is worth. And we ended up referring him to a bankruptcy attorney because what had happened was he thought that the franchisor had attorneys and they were looking out for him too. He had opened up a trampoline park in an area without knowing what other things were going on in the area and the viability, the feasibility that the franchisor had done. But it's important to get your own opinion and your own professionals to look at the viability plan and whether or not you think you're actually going to be able to make money. They opened the location, and then right across the highway, another location opened within 4 months.
Oh, no.
And so two things killed them. The school year started back up in the football season, and that's what he says, and the other location opening up. And so once that happened, it was now just going downhill. But if he had gotten an attorney, there's at least the possibility that he would have been able to avoid that. And the reason he wanted to sell it for 1.2, 1.3 million is because that's how much money he had put into the process.
Oh, no.
Without getting an attorney.
Wow.
And reviewing franchise documents is not, 1% of that.
Yeah.
So it's just something that if you get an attorney, you're going to have somebody in your corner. For a joint venture is essentially a partnership agreement with a very particular and limited scope. So, it might be about a certain building project or about a series of developments or about a certain geographic area. I know there's a joint venture for the stockyards in Fort Worth, for example, for managing the buildings and its collection of buildings, and they've done a good job. But it's basically a partnership agreement, and those, I think it's very important to have an attorney for, because if it's going to be limited in scope, you need to know, when does it end? How does it end? What are the different ways it might end? And who's responsible for what? because if it's limited in scope, usually there's a project that's getting done. So if there's a project that's getting done, who's responsible for managing the project? Who's responsible for the costs? Who has the authority? Who has the responsibility? Who gets the profit? Who gets paid in what order? Those things are very important in a joint venture agreement, among other things. And then for mergers and acquisitions, this is a classic situation where the non-monetary terms can kill you. You might think, I'm getting everything I want. That says, I've got cash and stock options worth $10 million. But then at the closing table, you only get $2 million and $8 million's in stock options. And then you're a minority owner in a company where they can dilute you further, and you're not going to see that money for years. And, that's a situation where, I got what I wanted on the term sheet because it looked nice, $10 million. But, digging into it, having an attorney that was able to explain it to you and make sure that things are playing out the way that they're supposed to you're a minority owner in this company. What are your outs? What are your rights? What abilities do you have as a minority owner to make sure you're going to be paid or to be protected from having your interest diluted? What's to stop them from bringing in other people? And now your interest that was worth $8 million is worth $4 million because suddenly they, perform some sort of stock split or something else where they dilute your interest and its value. So those are the kinds of things that, you should think about, and there's others as well. But it's just a lot of things.
It is. It's a lot of things.
Yeah.
I know. As a business owner myself, there's been many times I've called you with very unique things that have happened in my world because you don't plan for the unexpected.
Yeah.
But you need to at least have, it's been wonderful to be able to have you to be able to reach out and say, okay, this just happened. Is there something I need to be concerned about?
Yeah.
And then tweaking an engagement letter or something is always protecting of that. But as business owners, and like I said, we don't go into business thinking someone's going to sue us or we're going to get into some weird legal dispute. We truly try to go into business because we're passionate about our craft or our skill. But is there anything that we could potentially do that could help prevent disputes and litigations? Or are we just, life happens?
So I definitely think part of it is life happens. There's a saying amongst attorneys that if you practice long enough, you will have a malpractice claim. So,
I'm retiring tomorrow. I'm just letting you know, Jen, I'm retiring tomorrow with a clean record.
So far I don't have one, but it can happen just because somebody doesn't like the service they got, even if their fact situation was just horrible and they just, are unwilling to confront the facts. So for business owners, what I would say is setting up processes and best practices so you can mitigate potential risks, right? If you do all of your deals with no contracts on a handshake, you're going to lose money. You're going to get stiffed. So if you have contracts, that puts pressure on the other side to know you've got leverage now. You can go to court. You have something to stand on that they've signed. So that's a way to mitigate the risk there. Internally, with employees, having an employee handbook, having employment agreements. So that way there's practices set up around those things. So it also helps just from a communication standpoint, signaling to other people that you take these agreements seriously. If you do everything on a handshake deal and all your employees have no employment agreements or at least an NDA, then that signals to everybody that you are taking that more casually and that there may be some exposure there for you and that they can apply some pressure trying to claim that it happened this way or that way, and you turn it into a he said, she said, as opposed to if you use contracts, then you're signaling to those people that this is what we're going to use if we end up going to court, and they know that. Then you can look back at the agreement, quote it back to them in case you have to remind them sometimes, and then they go, oh yeah, okay, and they will fall back in line, hopefully. Now some people will still say sue me, in which case you have to go do that, which is part of the life happens. But I think a big part of it is just the mitigation is in taking it seriously and having those best practices in place on the front end.
Okay. Yeah, that makes sense. All right. So let's talk a little bit about the Corporate Transparency Act and what business owners should know about it. Now it's making it all in the news. Certain states are saying it's unconstitutional. So
Can you talk about this Corporate Transparency Act?
I will talk about it as it was in January, because I don't know what the most recent updates are in the last few weeks, and I try to stay up to date, but usually I'm a month or two behind in terms of what's in the news, and also legal changes happen slower than the media cycle. So
here we go, controversy.
I will say I know that it was declared unconstitutional in a particular case. I don't remember the name of it, in Alabama, in a federal court. I don't know about any other states or any other cases, and that case has not been appealed to the Circuit Court of Appeals or the Supreme Court yet. So it's only applicable to the people in that case.
Mm-hmm.
So for everybody else in the world, to my knowledge, it's still applicable. Now, what is it? It states that it's for the purpose of preventing money laundering and financial crimes. So how are they achieving this? They're requiring from every individual, because they require this thing called a beneficial ownership information report, in which every individual that owns 25% or more, or that might own 25% or more if all the stock options were, or various ownership options were exercised, has to disclose their current residence, their social security number, their birth date, photocopy of their driver's license or passport. Is there anything else? Those are the majors. There may be one or two other points that I'm missing because I don't have it in front of me, but those are the majors. I mean, social security number, birth date, photocopy of your driver's license or passport.
They know everything about you.
Yeah. And then current residential address. And if any of those change, which really just means if you move, because the others aren't going to change. If you move, you have to update it within 30 days. And if you don't update it within 30 days, it's a $500 a day fine. So now add that to your list of things you need to take care of every time you move.
Yeah.
And when you form an entity, so this is another reason I don't necessarily recommend LegalZoom, although I don't know if they do CTA filings. They might do those or claim to do them. But LegalZoom, to my knowledge, doesn't do those. I've not checked them in the last few months, so maybe they do the Corporate Transparency Act filings. But if LegalZoom doesn't, now you've got a situation where you've formed an entity and you were supposed to have filed this report. If you filed this year, you've got 90 days. Starting January 1, 2025, you have 30 days to file the beneficial ownership information report. Now, there's a lot of issues surrounding how it's worded, because if you are a beneficial owner, it's if you have 25% or more ownership, or if you could. So if we had 5 owners that each have 20% ownership, but each of them have an option whereby if they exercise the option, they could get another 10%, so they'd be up at 30, and each of them has that option separately, then each of them has to be analyzed individually. So each of them it now counts as being above the 25% threshold because of that option. So even though there's 5 owners at 20%, the fact that they have that option makes them all beneficial owners that are above 25% because they could be. So all of them would have to report. Also, if you have an entity that is owned by another entity, that entity, you have to disclose the owners of that, because they are interested in the humans. Who are the humans? The pieces of meat at the end of the social security number, at the end of the holding company, within the holding company, within the holding company, that actually own this thing, because that's how they think they're going to prevent these financial crimes. Now, you're exempt if you're a publicly traded company. You're exempt if you make over $5 million gross revenue, I believe. You're exempt if you're, there's like 23 different exemptions or more, I think. So there's a number of exemptions, but the fact that you're exempt if you make $5 million or more in gross revenue points to the fact that they're targeting small businesses, which maybe statistically that's where most financial crimes occur. But it's something that I think has the potential for political abuse, because we've certainly seen agencies in the government be used for the purposes of one party or another at various times. And so I think that the potential abuses for this lean more heavily one direction, because most small business owners are right-leaning. So if this was going to be abused, the information within FinCEN, which I'm sure is wonderfully protected and could never be hacked by any foreign government, cough.
Yeah.
That could end up in the wrong hands and be used against us somehow. How, I'm not exactly sure, but it certainly would be frustrating. Also, it's just one more thing that somebody can bring up if they feel like somebody's a nuisance, but they own a lot of entities. It's just one more thing that they can go check and go, oh, you actually didn't file these things that you were supposed to file, and now you get tagged with these huge fines for this administrative miss. So I think also it's important, going back to just some of the pragmatics, to the less controversial.
I was ready to jump on the controversial wagon, but I'm gonna hold back.
Okay. You should use an attorney for the filing because there should be an analysis of who a beneficial owner is. Also, another prong is anyone that exercises substantial control over the entity should be disclosed. Well, who exercises substantial control? Well, as the government does, their definition is wonderful. They actually use the word substantial control within the definition of substantial control. So who exercises substantial control? Anyone with substantial control. There's also some other factors, but the fact is that it's somewhat nebulous. And if you have a small business, a medium-sized business, it's much more nebulous. Now, if it's a single owner, there's no issues there. The beneficial owner is the only one that's exercising control. But if you have 10 or 20 people, does your accountant, does your attorney exercise substantial control? Because it's somebody that determines which contracts you enter into, how you spend your money, how you file your taxes. Now, they explicitly released a statement to make attorneys and accountants and CPAs and EAs not as afraid of the CTA, where they said professional services people do not count for small businesses as exercising substantial control. But let's say you have an administrative person, but they determine which bills get paid when. Are they essentially a CFO for that small business? Yeah. Are they exercising substantial control? If you have an HR person, but that's all they do, they're not a director, they can't sign on anything, but they're deciding who's hired and fired and how to handle complaints. Are they a person with substantial control? So that's something that needs to be analyzed for any business that has employees. So it's important to use an attorney for the filing.
Sure. I agree. Definitely. Do you have any other words of wisdom that you can share with entrepreneurs out there that maybe we didn't cover in this podcast?
Sure. I'll go into some non-legal words of wisdom because I feel like I've covered the legal side a lot, but I do have my own firm that I started right at the time that I met Monika. Yeah. Actually, interesting fact about us, we met the week that I started my own firm. So it's been a wonderful friendship, and I've definitely enjoyed that.
Thank you.
So I would say first thing at the beginning, if you're a small business with networking, I would view networking at the beginning as cast a wide net. Go to every function you can, meet as many people as you can, follow up one-on-one. And over the course of a year or two, you'll start to see naturally where the synergies are. Who's able to refer you clients? Who are you able to refer clients to? And as you see where those synergies are, then you can narrow your focus into seeking out those kinds of professionals where there's going to be a mutually beneficial relationship. It's still useful to be plugged into some groups just so that you're involved with the local community. But I think don't get discouraged if in the first year everything isn't just humming along. It takes time to build a network. Also, don't be afraid to charge. If everybody says yes whenever you make your pitch, it might not be because you're the world's best salesperson. It might be because you're not charging enough. So as a small business owner, make sure you know your worth. If you don't get it, I would say at least 10 to 15%, and some people would say higher, but at least 10 to 15% should be saying no just because they don't like your price. Because if everybody likes your price, then it's like they said, the quote from the movie Rounders, which is a poker movie. If you're at a table in a local game and you can't spot the sucker after the first hour, you're it. So next, manage your time. Don't try to do everything every day. So try to create some time blocking where you say, okay, on Mondays in the morning, I'm going to do admin, or on Fridays, I'm going to do phone calls. Have some sort of system so that you don't just feel like you're just running around with it like a chicken with your head cut off every day, because you'll end up leaving the day frazzled and tired. Whereas if you have at least some system, it doesn't have to be super regimented, but but just have some level of time blocking and some weekly systems in place that will help you with managing your time. It helps a lot to get priorities done and to feel like you're not just putting fires out all the time. And then last is you don't have to be an extrovert to be a good business owner or networker. There are great introverts that are great networkers. In fact, here's a plug. I would say introverts are better at networking sometimes, because if you go to a big event, the extroverts will go, where are my friends? I need to see all of them. But your purpose in going to a networking event is to find new people to meet with. If you want to see your friends, you can ask them out to lunch one-on-one or to coffee one-on-one. But your purpose at a larger networking event is to try to seek out new people that you can meet with. So an introvert is generally going to be more purposeful in that setting than an extrovert who just wants to say hi to their friends. No knocks on saying hi to your friends, that's fine. But that's just an encouragement to you introverts out there that you can be just as good, if not sometimes better than the extroverts at various aspects of business ownership.
And the irony is the attorney is the extrovert and I'm the introvert. And before I even went into the networking event, out comes a hand and, hey, I'm Aron. Who are you?
Yeah.
Let's go have coffee.
Yeah.
And that was it.
Yep.
Oh,
Yeah.
very much. That's great. Well, thank you so much, Aron. This has been absolutely wonderful. I really appreciate you taking the time to be out here and talking about some law things that the entrepreneurs out there can really benefit from. And we will definitely put all of your information out there. So if anyone found this information very useful or very valuable and would like to reach out to Aron, maybe for a consult, or actually has a pressing legal need, we will definitely put out his information out on the podcast. I can personally definitely vouch for your expertise and trust you 100%. So
Thank you.
thank you everyone for tuning in and watching this episode. I'm super excited to sort of expand on this in a couple weeks and kind of talk about some tax savings and strategies just by tweaking what legal entity you choose for your business. So thanks a lot and have a great day.